Hello, I am Stephanie Joy, the attorney at All Things Social Security and Joy Disability Law. Your video is about to start. I just wanted to remind you that if you click the join button below, you can learn more about the memberships offered at a very affordable price that can give you a little more direct attorney answers to your questions. Have a great day and enjoy the video. Okay, really interesting question posed by somebody. It has to do with being a widower, being on disability, and turning 62. So I think the situation is that we have a person who's disabled and collecting disability, and then they become a widow and they take widow benefits. It sounds like at 62, maybe the spouse just passed, and the widow benefits, despite being reduced for taking before full retirement age, exceeded her own disability benefits on her in-work record. So she switched to the widow benefit, but she has since learned that by taking the widow benefit at 62 and getting that little bit extra from what her own would have been, she is curtailing the possibility of getting 100% of her deceased spouse's benefit amount, because she decided to take it at 62 instead of, say, per se 67, her full retirement age. I'm presuming it's 67. So the question is, can I reverse that? And generally, yes, you can. She is eligible on her own for disability still, because she's still disabled, presumably. So she can contact the SSA. She can withdraw her widow application, I believe. I mean, you could do this with retirement too, in certain instances. Within the first year, for sure, if you decide it was a bad move, as long as you pay everything back. In this case, what I would foresee is that whatever she collected, the little boost she got for getting the early widow benefit, she'll have to pay that back, just the boost part, to bring it back to the disability part, and then continue on with the disability until age 67, at which time then, instead of continuing on with what would be disability turning into retirement, which it automatically does, she would then instead apply for that widow benefit at the full 100% rate of her spouse, instead of taking, say, 75%. So it can be quite a significant amount. So I think that's what the person was asking about, and I think that's the way I think it's going to go. But you're going to have to pay back the overage you got when you filed for the higher widows. Even though it was reduced from what it could have been, it was still higher than the disability amount. So I hope that is being explained okay. One thing to always remember with widow benefits, we can take them at 60. Widow, widower, doesn't matter. But it's going to be, I believe the number, I want to say it's 71.5% of our deceased spouses. I want to say primary insurance amount. It might not be the primary. If a deceased spouse had delayed taking his or her own, there might be delayed credits in there that usually pass along to the surviving spouse. That's the beauty of the one that passes early, not taken so early. Like if he can wait till 70, it's growing only, not only his own rate that he will hopefully be able to collect, but should he or she pass, the surviving spouse, if they have their own lower amount, they can jump over to the full high age 70 amount of the deceased spouse. But when we take it 60 years old or 61, 2, 3, 4, 5, we're going to have that incremental reduction, just like we do if we take our own retirement early, because we're taking extra credits, and it's supposed to be a retirement benefit. So it's a survivor retirement benefit, of course. There is also, not to forget, the widow benefit one can take at 50 to 60, say, when you're not quite old enough for the 60-year-old benefit. If you are disabled yourself, and if you became disabled within 7 years of the passing of your loved spouse. So if you're disabled before your spouse passed, that is always deemed to be within 7 years, right? Because even if it's 20 years before, you are certainly disabled within 7 years, you know, in the disabled status within 7 years. And you probably may not have even approved it to the SSA, so you might not be getting SSD benefits because of it if you didn't have a work record. But if you can prove when your spouse, if your spouse passes and you're in your 50s, that you are disabled as per SSA criteria, then you can get your spouse's benefit, something based off of your spouse's work record. Okay, so different kinds of widow benefits there. But again, the person in their 60s that took the widow benefits then realized they wanted to pull back on that and let it grow so then get the full amount at 67. You can do this. Go contact them and find it. You can do this. All right. Be well, guys. Hey, so if the subject matter of the video you just listened to is of interest and you want more on it, stay tuned. Here's another one about the same topic, but a little bit different. Bye now. Good morning. The SSA just put out a little article online, but most people probably don't see them. I get email alerts from them. And it was just a reminder and I thought it was helpful because some of the things that they put out are really kind of impractical for everyday internet users. But this seemed a little more practical, and I wanted to reiterate it. It's when a widow will be eligible for benefits, because there's a few different times when he or she may, widow or widower. So let's just go over that really quick. A widow or widower may be eligible for benefits if they are age 50. Now, SSA didn't mention this in their article, but you have to also become disabled as that widower or widow within 7 years of the passing of the spouse. So your spouse passes, you become disabled, and you become 50, and all that happens within, well, the disability happens within 7 years of the passing of the spouse. You could be eligible for benefits on the spouse's work record, because you wouldn't necessarily be eligible on your own work record if you didn't have one sufficient at that time. And that could be a variety of reasons. Now, I remember a particular case when this happened. I was actually proving a disability case for someone, and then the issue arose that the spouse was passed. The unfortunate thing, and she would have gotten more benefits under the spouse's work record than her own. Like, she would still get them on her own, but they were much smaller. So she'd get them on her own if she proved her own disability, which we were able to do, but she could get more having proven disability if she could prove that she was married to the alleged spouse, which was the parent of her children. If she could prove that marriage. Ironically, she couldn't. She could never get a document saying it. And her children, even, they didn't know. It was before their time. It was all kind of understood, which, as children, we don't necessarily see our parents' certificate of marriage. So she never could prove that she was married to the gentleman that had passed. I don't really doubt that she was, but for whatever reason, and she had no recollection of even what state it was in. This is how bad off she was. So there was no, you have to go through your state vital statistics and all that stuff. And that is always left up to the person to have their marriage information. So she didn't prove that. And the kids never saw a certificate, anything of that nature. So that didn't pan out for her. But, for everybody else who actually keeps track of that stuff, it's worth noting that as early as 50, you could collect a benefit based on being a widow or widower, whether you have your own work record or not. You could have been a stay-at-home and not have one. At age 60 is the one we normally think of as a widow's benefit start date. I kind of consider it like a widow retirement age. Normally we can collect a spousal or ex-spousal benefit at 62 based on a prior spouse's work record. For widows, and by the way, they could be divorced widows, 60, it starts 2 years earlier. However, like the age 62 early taking of any kind of retirement benefit, this benefit will also be discounted. So if a widow or widower wants to take it at 60, they're going to be taking about I think it's 71.5% of what they would take as a widow if they waited until their full retirement age. So it is substantially decreased. And no, it doesn't pop up if you take it early once you hit retirement. Some people say, well, is it going to go up when I hit it? No, you're taking X years of additional payments. So let's say it's 6 years of additional payments. That's 6 times 12 months. That's 72 payments that the other person who waits till full retirement age isn't taking. So your discounted amount, your reduced amount for taking early is permanent. So that's a risk people can run. Is that going to be enough money later, or was it better to maybe plug a few more years of work in, and not have to take that? If widow's benefit is going to be the thing you rely on, so obviously you're going to weigh those competing amounts. Is my own benefit going to be more than the widow's? Doesn't matter, and I could take it. One thing about widow's benefits too, if you take it, it doesn't impact your own. If you had taken at 62 early spousal benefit, that's deemed as taking your own benefit, and you can't then later try to hop to your own record at the full amount later. That's not true with the survivor widow's benefit, and I hope they don't change that. If you take it early, it does not count. It's not deemed as having taken your own. So you can take the widow's benefit, let your own delay. And so you don't get that penalty if you take your own later. So that's kind of a nice thing. Thank God they didn't take that away from the widows and widowers, because they took a lot away in 2015 from spouses. So they didn't really touch this one, thank goodness. You can also collect a widow's benefit, a survivor benefit based on your spouse's work record. If you have a child, that person's passes, and you have a child under your care who is under age 16, or if they're disabled before the age of 22. So basically, we refer to this as the widow caretaker benefit. That widow benefit will end though when the child turns 16. So keep that in mind. If the child is disabled and deemed that by Social Security, whether it's through an SSI finding or what have you, then as long as that child remains disabled and being cared for by the widow or widower, that caretaker benefit can continue. Going back to the age 60 taking of the benefit, that requires that you're not married. However, you can take it later if you remarry, if your remarriage is after the age of 60. So if you collect a widow's benefit at 60 and remarry at 62, you don't lose your widow's benefit. If you remarried, if you were widowed at 58, had no benefit because you weren't 60 yet and you weren't disabled and you weren't a caretaker, and you remarry at 59, you just lost that. Now, if you get divorced, you might be able to revert back, but so just keep that in mind. Sometimes delaying that marriage till after 60, if what you want is that widow benefit, versus if you have a better one yourself, or you have to again weigh all those different amounts that will be had at different times, eligibility, and which ones would be impacted if you collect now versus later. So you can kind of weigh the options of taking now versus later. So anyway, I hope that helps you. That's basically 4 areas of widow or widower eligibility to keep in mind if, gosh forbid, you lose your spouse. And again, these can apply if you're divorced from that spouse as well. So, so pay attention, and I hope that helps someone who might otherwise have foregone benefits because they didn't know about it. Have a great day.